So, on behalf of CIPIL and Lionel and everyone else at CIPIL, welcome very much to Cambridge. So I'm going to sort of start where Surabhi ended and trying to indicate, broadly speaking, linkages or interfaces between intellectual property and human rights. And I want to do so by sort of starting with certain concepts, our sort of primary ideas of what IP rights are and perhaps what human rights are. Whether they are sort of, probably need to be revisited and how that informs perhaps then secondly our perspectives of the relationship between the two. And there may be many more perspectives, but I want to focus on the one hand on sort of how we can use human rights in order to protect intellectual property, how that has been sort of done, for example, relying on the right to property, but also this sort of more ambiguous notion of creators' rights under the International Covenant for Economic, Social and Cultural Rights. And when you talk about the right to property, there's a functional equivalent outside the human rights system, which is investment protection. So international investment law essentially needs to be equated to some extent to the right to property. So I will make some reference to investment protection as well. Also because we have some high-profile cases where intellectual property rights are being sought to be protected by means of international investment law and international investment treaties. Tobacco is one, Eli Lilly in Canada is another one, and there's apparently something from Novartis in Colombia about pharmaceutical patents as well. So then the other side is to look at human rights and how arguments about human rights compliance affect the question of whether or not IP treaties or IP laws, IP protections will serve as a sort of, tool to promote human rights or in fact are in conflict with human rights. And I want to rather can't really point to too many cases, or at least I'm not going to discuss essentially core cases on the national level. On the international level, because Surabhi has indicated there's hardly any sort of effective means to litigate compliance with human rights, especially access rights, rights to food, right to health and so on and so forth. So I want to focus on the kinds of narratives which have been sort of employed by human rights bodies. And there's an interesting trend from a narrative of conflict towards a narrative which essentially uses intellectual property as a tool to achieve compliance with particular human rights. I'm sure that's something which Larry Helfer at the very end, when we come to the to the Marrakesh Treaty for copyright exceptions for visually impaired persons and the blind, is a sort of, probably a core example for that. And then on the last level, looking particularly at tools for integrating in adjudication and dispute settlement, again, I want to sort of pick up these two perspectives. On the one hand, the role of human rights arguments in WTO TRIPS disputes. I can't really present you there any sort of decided cases, but I can present you complaints. On the one hand, where the complaining state, an example from India and Brazil, uses human rights arguments and certain other arguments from the TRIPS agreement in order to complain about EU and the Netherlands blocking generic drugs in transit as sort of an argument where they try to sort of infuse human rights into the TRIPS dispute settlement system. The same is in the ongoing plain packaging case, where, however, of course, the defendant, Australia, relies exactly on the World Health Organization's Framework Convention on Tobacco Control, which is in that sense not a human rights treaty, but the Framework Convention essentially is informed by the right to health, and that is sort of referred to in the preamble of the treaty, plus in the preamble of the document constituting the World Health Organization in the first place. Then on the sort of, reverse situation, the role of intellectual property rights as domestic private rights in sort of international human rights cases, primarily cases from the European Court of Human Rights. And again, you have the functional equivalent with investor-state arbitration. So if we have a domestic property right, a core question is, how does it relate to an international system protecting that particular right? The limits embodied in the national law, can they then serve nevertheless as interferences with sort of an international system protecting that against expropriation, unfair treatment, and so on and so forth? Is a compulsory license an interference with the right to property or an inherent limitation of the right? if we have a sole negative right to exclude the trademark holder from others using that particular mark, how can plain packaging be in fact anything which interferes with that right, because it's simply the state constraining the use rather than the third party sort of being enabled to do something. So these are some of the things I want to address. I'm not sure if I'm going to manage that in 30 minutes. I'm sure Richard is going to stop me. But maybe I get 5 minutes extra because I think you overran a little bit. Anyway, so let's start with the concept. So, I mean, IP rights are private rights, right? The TRIPS agreement in the preamble says members recognize sort of this private rights feature of intellectual property rights. They're essentially rights in the horizontal relationship between private parties, where the state affords protection and the user has to acknowledge and is limited in the way by these private rights in terms of what is covered by subject matter, not to engage in activities under these scope of these private rights. So that serves probably as a starting point, on the one hand, for sort of the conflict narrative from the human rights perspective, because you can say, well, if these are private rights to exclude others, to use things which are essential for, giving effect to certain access rights, access to health, access to food, access to education, then intellectual property rights as private rights potentially interfere. You could, of course, say, well, then recognizing the second part here from the TRIPS preamble, well, these private rights are not an end in themselves, but they have a utilitarian function. They serve a public purpose, right? So that's recognized in the TRIPS preamble as well. And these 2 points in the preamble immediately link to another. And that serves maybe as a justification for saying, well, of course, we grant these private rights essentially as an incentive to create these useful goods in the first place. That's the main utilitarian justification for intellectual property. And it also implies that these rights are not unlimited, but these rights are subject to exceptions and limitations, perhaps licenses enforced upon the right holder, like compulsory licenses, limits on the subject matter, and so on and so forth. You all know this. But here the core point is really to say that these underlying public policy objectives serve later as a very important argument for the human rights system to claim to use certain tools within the IP system to promote human rights aims, right? Conceptually, IP rights as private rights, of course, are different from human rights, which are, at least in the traditional starting point of the post-Second World War period, are rights against state interference, primarily conceived as rights against state interference, right? But as Sorabi has pointed out, that's not the end of the matter. It's not only the right to respect and to, not to infringe human rights, but it's also a duty to protect, and it's also a duty to fulfill certain human rights. So the rights against state interference, if that's our starting point, then obviously the kinds of, even if we consider, say, under the right to property, intellectual property as an asset protected, then if it's only a right against state interference, there will be only limited situations when you can use that particular right against, in order to protect your intellectual property. Because as long as it's simply about a third party, a private party using your intellectual property, and you want the state to do something, well, then it's effectively not necessarily a state interference, and you don't really have a claim. However, if you take the second level into account, the duty to respect, then of course it's, the duty to protect, then of course it's much more that the state has to set out a system which allows you as a right holder to, protect your right against third-party interferences. And that's something which we'll see in the case law of the European Court of Human Rights in the Anheuser-Busch decision, where they refer to this duty to respect. It wasn't necessarily very much at stake in that case, and they didn't further flesh it out, but it's an interesting point where you see that on the regional level, the European Court of Human Rights has accepted that the right to property is not only a right against state interference, but it also is a duty to protect, right? So these are I guess, two initial conceptual points to make. So then moving on to the different perspectives. I want to start on the human rights protections for intellectual property. Some of that has been mentioned by Sorabi. Other presentations will follow on. So I'm going to be rather brief. I'm just going to Well, mention the Universal Declaration again, where you have, I think that's the only document which puts together both the right to property approach and the creators' rights approach, which are, from the human rights perspective, probably the two different paradigms to looking and which are relevant for the IP context. The property right, of course, emphasizes the property element of intellectual property. It's essentially the means by which we protect intangible creations by granting property rights, which is the starting point for putting sort of intellectual property under a right to property umbrella for protection. Because of these different political views essentially about property in the Second World War context, you only have a very weak obligation to protect this against arbitrary deprivations, arbitrary expropriations, I suppose, right? And that hasn't really played a major role as far as I know in any sort of human rights analysis to intellectual property. What has been, however, more highlighted and has been more fleshed out in a subsequent treaty is the Article 27 approach, which provides for so-called creators' rights. And the sort of more, slightly more detailed expression of that you find in Article 15 on the International Covenant on Economic, Social, and Cultural Rights, right? So this is one element of essentially, well, three different rights perhaps, or maybe it's even one right. You have the right to culture, you have the right to science, and you have these creators' rights under Article 15, Section 1c, the right to benefit from the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which an individual is the author. So that, of course, strongly links to copyright primarily, but is understood to go beyond copyright. We don't really have a very clear idea of what exactly that covers. It's probably, and it's often not necessarily equated with intellectual property. It's often said, especially by the general comment, which Surabi mentioned, there's a general comment on this particular right to be something which could be implemented by lots of different ways, by providing subsidies for authors and so on and so forth. So and I have a slide on that in a moment, but I want to just highlight one other point. In the second paragraph, the article talks about this right, and this is often understood as to refer that all the rights under Section 1 in Article 15 are one holistic right. So access to science, access to culture, and protection of the creator is part of one right. So there's an inherent balance of providing access and protecting the creator within that particular system. So if you try to sort of compare creators' rights with our traditional notion of intellectual property rights, and that comparison which I provided here is based on the comment on Article 15 and the concept of the creators' rights developed in that Article 15 comment. You see that the comment tries to highlight the differences, essentially, tries to highlight the inalienable nature of human rights versus the fact that IP rights are merely state privileges granted, and they are temporary, they're transferable, they're territorial, whereas human rights are claimed to be inalienable and pre-existing, essentially natural rights. I'm not going to go through all the different points here, just to highlight, for example, that the protection of human rights goes beyond sort of the concept which we have in international IP law, where you can invoke, or not necessarily even directly invoke, but the protection is limited to foreign right holders from countries of another WTO member state, or the Paris Convention, or the Berne Convention, and so on and so forth. Human rights, of course, are not limited to protecting foreign nationals, but of course cover also their own nationals. So there's a range of sort of differences which this sort of general comment highlights between the IP rights as we understand them and the notion of creators' rights. And that's important for the later narrative of conflict, which was set out to some extent early on by human rights bodies in relation to intellectual property rights. Moving on then to the right to property. So Surabi has mentioned the first protocol, the notion of protecting possessions. It doesn't mention IP anywhere, but as we will see later on, the case law of the European Court of Human Rights has acknowledged that these kinds of protected possessions would include intellectual property, and in fact do even include things like an application for a trademark in the Anheuser-Busch case. An important point maybe to make here that the article talks about two different ways of, well, I wouldn't say interferences, but limits to the right to property. Deprivations, which seem to be the more severe expropriation type of limit, but you also have controls of use of property, which are treated differently and are meant to be sort of differentiated from expropriations or deprivations. You will see that in the case law of the European Court of Human Rights, this is not necessarily always adhered to, because the Court of Human Rights takes a sort of approach to interpretation which identifies sort of something to fall within the ambit of a protected right, then identifying an interference, and then looking at a possible justification, proportionality essentially. But there is this sort of differentiation, and that is a core difference. One more word on the EU Charter. Essentially, as Surabi was saying, building on the sort of basic notion of protecting possessions under Article 1 of the first protocol, and it has this very interesting sort of second paragraph, which simply states intellectual property shall be protected, full stop. Christoph Geiger has written an interesting article which puts a nice question mark behind that particular phrase, because we probably don't really know what it means that intellectual property shall be protected. Is that an absolute statement? Are there no limits to that? Well, probably not. But so what does this sort of, provide us further in our understanding on how we protect intellectual property? And I think we have presentations on that, so I'm not going to talk about that or speculate about that. Lastly, just to point to this sort of, functional equivalent again of investment protection, right? So investment protection essentially, and I'm using the example of the first modern BIT between Germany and Pakistan from 1959, has always sort of protected investors, foreign investors, for the investments, any sort of assets essentially, which they make in a host state. And these kinds of protections have traditionally covered intellectual property. At least in this first BIT already, Germany ensured that patents and technical knowledge, whatever that means, are considered to be investment. And the protection afforded is usually one which protects against expropriation, state interference, but also provides full protection and security, which is probably the more active duty to somehow protect against third-party interferences. This notion of full protection and security has, in international law, by the International Court of Justice, been understood as an active duty, but due diligence, essentially, obligation to protect. An interesting point here, just to note that the protection against expropriation, if you compare it to the sort of human rights protection under the first protocol, is significantly stronger because it's always subject to full compensation. So you always owe, not always, but in essentially all circumstances under BITs, you owe compensation for the value of the investment at the time, for the full market value of the investment at the time the expropriation or before the expropriation or state measure occurs. So the amount of protection afforded is more. That's why most of the debates in international investment law are about whether, in fact, we have an expropriation in the first place, rather than looking at under what circumstances it's justified. And compulsory licensing and other things have been discussed as potentially amounting to an indirect expropriation. Right, let's move on quickly to this sort of idea of, employing human rights arguments to essentially constrain intellectual property. This is a photo from South Africa in the late 90s, where pharmaceutical industries brought a case against particular aspects of the then Mandela administration to introduce certain measures to make generic drugs more accessible in South Africa, in particular for HIV/AIDS. Interestingly, one of the arguments which the pharmaceutical industry used in order to argue that this is a breach were right to property arguments under the South African Constitution. So this has, of course, created the situations where NGOs and lots of others complained about the use of intellectual property essentially to limit access to medicines, limit access to the right to health, and so on and so forth. So you see in an earlier resolution by the UN Subcommission on Human Rights from 2000, essentially a conflict narrative, right? On the one hand, apparent and apparent conflicts between intellectual property rights, their implementation on the domestic level, but even international treaties such as TRIPS are being sort of identified. And then the second step is essentially to say, well, there's a primacy of human rights over international economic law. It's never really made out why exactly there would be such a primacy. The arguments in this declaration don't really sort of speak further to this. There's some special reports by, for example, Oliver de Schutter, the Right to Food Special Rapporteur, who makes some arguments about on the basis of Hughes Kogan's, on the basis of the UN Charter, and so on and so forth. I'm not going to go into that, but most agree that these arguments are not necessarily very sustainable about this primacy. But the core point is that there's a narrative created where IP rights interfere with human rights, and giving effect to human rights, and human rights are above in a level of hierarchy. So what kind of conflicts are there? For example, IP rights impede transfer of technology. The right to food is impeded by plant variety rights. Biopiracy occurs in the sense that you afford private rights to derivatives of natural genetic resources, and thereby you deprive those traditional users, traditional knowledge holders, indigenous communities of their opportunities to use and benefit from these genetic resources, and you probably even deprive states of their sovereign right to control these resources, as the CBD puts it. And then there's this, you know this very well, of course, the access to medicines versus patent protection argument. So there's this sort of inherent narrative of conflict which we begin with. Just a little bit later, this kind of stick approach, where you kind of punish the IP owners or those states promoting intellectual property rights and consider them to be sort of perpetrators of human rights violations, that stick approach shifts to a carrot approach. And this one is now where you essentially make human rights arguments in order to say that there is a view to the TRIPS agreement, for example, which can be sort of human rights friendly. There can be a human rights compliant version of TRIPS, interpretation of TRIPS, construction of the agreement. If you just look at the sort of, main Roman 1 point here, human rights framework for analyzing the TRIPS agreement. Then at the sub-point letter D, a human rights approach to the TRIPS agreement. And you'll see that if you read this document, the main emphasis is on the flexibilities in the TRIPS agreement, highlighting the utilitarian function of intellectual property rights, making an argument that these are sort of essentially rights to achieve a social purpose, a public purpose, and therefore we have to understand them in this sort of access to medicines, access to food, and so on and so forth context. So the focus shifts towards praising the balancing mechanisms within intellectual property law. And the interesting element is that you're essentially employing intellectual property arguments and tools in order to achieve human rights goals. Right, and that's something you see in this sort of these soft law documents. Larry has written about this more than 10 years ago, and needs to get credit for identifying these essential sort of forum shifting means towards the IP system, using it as a sort of mechanism to employ human rights goals. And you see that then taken a step further, where TRIPS is all of a sudden not the bad enemy anymore, but TRIPS is the sort of, very nice, very flexible international framework which needs to be protected against being sort of undermined by bilateral regional TRIPS plus treaties, especially intellectual property provisions in that context. And you see the World Health Assembly, for example, encouraging states to not engage in these bilateral agreements which undermine flexibilities. The UN Special Rapporteur on the Right to Health again says LDCs and developing countries should not introduce TRIPS plus standards that may again infringe on the right to health. So now all of a sudden it's about ensuring TRIPS flexibilities, right? Then final step in that sense, and Larry is going to talk about that more, we now even have a treaty in intellectual property law which is essentially implementing human rights objectives, right? We have the Marrakesh Treaty which establishes mandatory, not optional as we usually always have, mandatory obligations to introduce exceptions and limitations for a human rights purpose, right? This treaty is there to ensure the right to read, right? Or the different rights which are affected for visually impaired persons and blinds who have not sufficient access to copyrighted material, because that material, even if it's available under a national exception, cannot be freely transferred, and there is not sufficient economies of scale to produce something in relation to Botswana based on their domestic exceptions, and then maybe something for Cameroon based on their domestic exceptions. So this is sort of, taking this sort of narrative to the current finite point, in the sense that you're essentially using intellectual property in order to achieve human rights objectives. And you see that very well in the preamble, essentially highlighting various human rights documents. Okay, I think I have to rush a little bit. So tools for integration. I can be rather brief on the first one. So the role of human rights arguments in WTO dispute settlement. So far, there isn't really any role for them. There has been attempts by, for example, India in this disputes about generics in transit being seized here in the European Union and the Netherlands, to primarily also rely on an interpretation of the TRIPS agreement which is affected by the right to health. Not only Article 7 and 8, but also the right to health. Right, and now in the plain packaging disputes, the one in Australia to be decided in the WTO, there were other disputes in Uruguay decided under investment arbitration, and there is a court case here in the United Kingdom. We'll hear about that later. But the core question in this dispute, in the WTO at least, is the role of the framework, or one of the core questions is the role of the Framework Convention on Tobacco Control and its implementation guidelines, for example, in affecting our understanding of the notion of unjustifiability under Article 20 of the TRIPS agreement, right? So can we directly apply the Framework Convention? No, we can't, based on sort of accepted jurisprudence of the appellate body in the WTO. We can't apply non-WTO agreement to a WTO dispute. What we at best probably can hope for is an interpretation of the notion of unjustifiability, which is in a way framed by, for example, the Framework Convention. Right, so then just very briefly, moving to the last point, looking at this sort of concept of domestic territorial rights in disputes which try to afford protection for intellectual property rights based on the International System for Protection of Property, here the European Convention First Protocol. So the European, and this is sort of from the Budweiser case, the European Court of Human Rights takes this idea of, or insists on an autonomous concept of possessions, where it effectively is sort of not necessarily accepting whether a national law defines something as property, but what it will essentially look at is whether a particular asset is legally recognized in the domestic legal system and has an economic value. The core point, however, is that it always has to refer back to the domestic law, because none of these property rights are established by virtue of an international treaty. And that's the same in investment protection. We have to essentially refer back to the national law, and that always creates frictions between national law limitations to these property assets and the international system of protecting them. And just to give you an example of that, in a very early decision by the Human Rights Commission, so for the body you needed to sort of pass by before you got to the court earlier on, this is a case about a compulsory license for a dependent patent. And the patent owner said that the compulsory license essentially was a breach of its right to property under the first protocol. So the Commission adopts this sort of three-step approach: scope of protection, interference, and justification. And the main argument I want to get as was the government of Netherlands saying, well, a compulsory license can never be an interference because the compulsory license is already existing in our domestic law. So any property asset protected under the international system comes from the outset with a limitation of the ability to introduce a compulsory license. And that, in that sense, the Commission says no, because effectively the compulsory license is not an automatic consequence of granting a patent, but is subject to a separate administrative decision. That's why the compulsory license can be seen as an interference. Well, but if that's the relevant test, then what about exceptions and limitations, which are essentially automatic consequences established in the law? They wouldn't ever amount to any sort of interference, right? Now, then in the investment arbitration, just an interesting point here. So again, question about can we see, and this is about sort of Philip Morris International complaining about certain health measures in Uruguay, essentially limiting the use of a trademark on tobacco packaging, and the tribunal had to answer the question, the investment tribunal established under the Uruguayan Switzerland BIT had to answer the question whether this is whether Philip Morris owns any assets protected as an investment which are capable of being expropriated. Right, and so it had to address this whole right to use argument. So Uruguay was saying, though trademarks only confer a negative right to use, therefore these measures, which essentially don't interfere with this negative right to exclude others from doing something, cannot even be an interference. And the tribunal effectively comes to the conclusion that trademark rights only afford, in that sense, the rights to exclude others. They rather frame it in a sort of absolute versus relative rights than negative versus positive, but essentially they say this is essentially a right to exclude others, and that's subject to the state's ability to, for example, protect public health. So from that you would say, well, then there can't be expropriation. But a few paragraphs down, the tribunal goes on to say, trademarks being property, their use by the registered owner is protected, and therefore these measures can constitute an expropriation. In the end, they say that they don't, but there isn't sort of the tribunal, in my view, doesn't really take the consequences from its earlier statement and follows it through, because it then somehow adopts this approach. Well, nevertheless, because of, I guess, the economic implications of these packaging measures, this can amount to an expropriation. So again, this sort of problem of delineating the role of the domestic legal system in construing a property right and the protection afforded by the international system. Lastly, and that comes back to the point about the obligation to protect. If the right to property is seen only as a right against state interference, like in the plain packaging situation, there the state interferes with your ability to use. Now that only gets you so far, especially in cases where you are sort of concerned about third-party, private-party interferences. Now, we have in the Anheuser-Busch decision the court essentially acknowledging that in cases especially involving litigations between individuals and companies or individuals, private parties, so where it's about delineating the users of intellectual property versus the kinds of rights exclusivity established, then the state obligation is essentially one to ensure measures necessary to protect the right. And that's, of course, an obligation which is essentially very similar to what we have in international IP treaties in terms of providing exclusive rights, providing remedies for enforcement, and so on and so forth. But here the interesting point is also that the right to property analysis here will only go so far, because the right to property in this sort of, or the role of the European Court of Justice in reviewing national courts' determinations of whether there have been sufficient protection afforded will only be one that ensures that the decisions of those courts is not flawed by arbitrariness or otherwise manifestly unreasonable. And that's a very important sort of, I think, very important, useful guidance also for investment arbitration when we look at whether or not, for example, a tribunal established to judge over the Canadian utility promise doctrine is enabled to do so and essentially rewrite Canadian domestic patent law. I think that's what I had to say, so sorry for running over a little bit. Thank you very much.